This is from the book Legal Fictions by Lon L. Fuller, page 26. What can be the motive of this obscurantism which talks of evidence that cannot be controverted? It is not plainly an inordinate desire to preserve the appearance of a likeness between actual and constructive notice, even at the cost of good sense. Instances like this show how far from the human from for the how far the human mind is willing to go to preserve a comforting and persuasive analogy. The whole field of vicarious liability is a branch of the law which, from its infancy, has been honeycombed with fictions, and what is more significant, with fictions that seems to resist the linguistic process of redefinition, with fictions that stubbornly refuse to die. Does not the explanation for this lie in the fact that the notion of vicarious liability is itself a bitter pill to swallow? So he's talking about the evidence of actual or constructive notice, and is it actual evidence, or is it fiction, and is the liability of fiction? So this makes me think of warrants, for example. Is a warrant an actual thing? Does it really say anything? Does it really have any authority or power or jurisdiction other than the force of people who make it happen? So in order for this fiction of a warrant or any other kind of notice, constructive or actual, to have any power, there have to be people that believe that it has power. And it's the belief in the power that causes it to come to life. So it's a fiction brought to life by belief. And so much of what the government does and its man's laws are just fictions, and you can read more about this in the book Legal Fictions by Lon L. Fuller, which is available on the internet in PDF form.